This ruling is not intended to diminish the significance of the victim's representative rights or concerns. Rather, it reflects the court's responsibility to regulate the presentation of evidence in a manner consistent with the integrity of the proceedings and the fair trial rights implicated in this manner. The manner in which evidence is displayed remains in the court's discretion. That discretion must be exercised in a manner that is appropriate and appropriately balances Mr. Robinson's constitutional rights, Ms. Kirk's rights as a victim representative, and the court's obligation to conduct the proceedings that are fair, orderly, and appropriately transparent. Transparency is an important principle, but it must be maintained in a manner consistent with the constitutional rights and protections afforded to all parties. The court does not make a blanket ruling as it relates to any exhibit, and as previously stated, each exhibit will be afforded its own due in weighing whether it shall be published to the courtroom or beyond or not. And that concludes the court's ruling on that motion. All right, counsel, the last matter, as it relates to the briefing, I'll hear that, and there is a slight edit to, and I'm not sure when the state wishes to publish State's Exhibit 16. So turning to the state, do you wish to be heard about the motions filed last night prior to the publication of Exhibit 16? Again, it's your choice on how you move forward. I just want to see which order you want to
go. We do want to be heard on the briefing from last night, and specifically about Exhibit 16. I'm understanding Your Honor has an additional edit to that. Is that correct? I do,
and there might be value in hearing that, so that may or may not change your positions. So let me just put that on the record, okay, and then I'll hear from you. I just want to make sure you're able to be afforded everything. So as it relates to the edits, last night, I believe it was between 6 minutes and 57 seconds and 20 minutes and 29 seconds, which is not to be played, and then 32 minutes and 55 seconds to 35 minutes and 47 seconds, which is not to be played. And I believe that what I received reflects that. And is that the understanding of the parties?
Yes.
All right, the state has said yes to the defense. I'm not saying if you agree with it, I'm just saying, does it reflect the timestamps?
May I have a moment?
Absolutely.
Go ahead, Judge. I think, Your Honor, and then let's just see what the court is referring to.
Well, I'm asking, did you receive a copy of the edited video?
Okay, so I'll answer that question directly. The state sent us a copy of the edited video. The redactions of the audio were exactly as the court ordered, but we noticed that the video, which followed, ended up being inconsistent with the redactions of the audio. So I brought that to the state's attention last night. I believe that they ultimately forwarded to the court what I'll call version 2 of the redactions, which redacts the video that would have made the audio redactions sort of superfluous or ineffective. So that's sort of where we are. But we may be not communicating with each other about the same issue. I'm not sure.
Well, okay, I just want to make sure that in regards to what was to be cut out comports with those timestamps I just gave.
It does, plus the parties believe that additional video needed to be cut out to match the court's intentions with respect to the audio.
Right, and this is where I'm going to next. Mr. Ballard.
Yes, Your Honor. I think we're on the same page. We did, in conjunction with discussions with the defense, first of all, we prepared the redacted video as Your Honor ordered. Then after discussing with the defense, we prepared a second version that still maintained the audio redactions as the court ordered, but we took out the video portions that the defense brought to our attention.
All right, and I didn't see that, but here, and this is the court's own independent finding after spending significant time last night reviewing it. So I'm requesting a video-only redaction between 20 minutes and 29 seconds and 25 minutes and 23 seconds. And so what I looked at was what was on screen. So any video showing anything other than Mr. McBride and Lance Twiggs was to be redacted, with the exception of the screenshots of the images pulled from the surveillance video and the FBI bulletin, which I believe was also briefly displayed.
I think we're all on the same page, based on what the court just said.
Your Honor, I think we have just a 1 second difference. Our timestamp is 25:22 of the additional edited version, but I think it still omits the video portion that we're discussing.
All right, well, it's a good day when we are literally on the same page. I'm glad that within 1 second we are all in agreement about this. So that the court, and it sounds like you're one step ahead of the court. I was going to say that if you had it, you simply turn off the monitor for that section. But if you've already made that change, then all the better. There are 2 additional changes as well. And this is very short, and so I'll leave it to the state if you wish to just in real time pause and fast forward, or wish to redact it. I'll leave it to you. So the additional requested audio and visual redaction, so this is not to be played whatsoever, is 27 minutes, 18 seconds to 27 minutes and 25 seconds. And the second is 28 minutes and 11 seconds to 28 minutes and 18 seconds.
Your Honor, just to make sure that we've got that correct, the additional redactions would be 27 minutes and 18 seconds to 27 minutes and 25 seconds.
Correct for the first one.
And then 28 minutes and 11 seconds to 28 minutes and 18 seconds.
Yes.
And Your Honor, while we're talking about additional redactions, let me approach. When Your Honor made his ruling yesterday afternoon, it wasn't entirely clear the basis for these redactions that the court proposed. The state's understanding was that those additional redactions were based on the potential that the video 1102 would be showing duplicative evidence and would be displaying evidence that would be duplicative of future exhibits, and then also potentially a concern about admissions by the defendant. Portions that the court has ordered to be redacted do not have any of those concerns as far as the state's view of that evidence, and I would like to be able to point the court to those. We've got 2 brief portions that we believe don't implicate those concerns and should not be redacted.
All right.
Does Your Honor have the transcript?
I do.
In front of you? Okay. First of all, at the very, very bottom of page 10, beginning with the words, "was he?" and then over to page 11, down to timestamp 1646. That portion is not cumulative of additional exhibits, and it contains nothing that could be classified as an admission by the defendant. That's the first portion.
So going back to page 10, I don't see "was he" at the bottom. Where are you? How many lines from the bottom up are you referring to? You may. Oh, I see, right here. Okay, now I see what you're saying. I missed that. I was looking at the beginning of the line, but I see your point. Okay. So from "was he" on page 10 until,
The timestamp 1646 on page 11.
okay.
That's the first portion. And then the second portion that we would ask not be redacted is a small portion of page 19. And it begins, let's see. It would be the fifth paragraph down, Mr. McBride stating "okay," and then ending at timestamp 3340. Again, that's not cumulative of any anticipated exhibit, and nor does it refer to any admission by the defendant.
Thank you. Yes, you may.
Thank you, Your Honor. With respect to the first of the two portions that Mr. Ballard referenced, I want to be totally transparent with the court, of course, that was not a section that we asked the government to agree to redact. That is a section that the court independently determined was appropriate for redaction under the various principles that the court has enunciated. So I just want to be transparent about that.
Thank you.
The second portion that Mr. Ballard addressed, which is on page 19, we did suggest, and it is in our highlighted, redacted transcript,
See that?
and the court agreed with us. This is not relevant. This is not admissible under 403. I don't understand how this questioning by Mr. McBride and the answers to these questions by Mr. Twiggs, and now I'm going to quote the Utah Rule of Evidence, has any tendency and reason to make a fact of consequence more or less true. That's the relevance question. So I understand that the court has said, I can make determinations of which portions of this transcript to rely upon, but from my perspective, what the state is asking the court to do is to broadcast a portion of the transcript which we are saying is not relevant, and to the extent it has any relevance, is significantly outweighed by undue prejudice.
All right.
I am not Mr. Twiggs' representative, but I think as a witness who has counsel, there might be something that Mr. Twiggs' counsel would want to say about this as well. I don't know what it would be, but my firmly held belief is it would be consistent with what I'm saying, which is that it is neither relevant nor probative of anything of significance, especially in compared to the undue prejudice. Thank you, Your Honor.
Thank you, Mr. Novak. Mr. Ballard.
Thank you, Your Honors. Mr. Novak recognized Mr. Twiggs was represented during this statement. His counsel knew that this was being prepared to be produced in court, and his counsel made no objections to this part of the interview. And this is critically relevant. It provides important foundational information about Mr. Twiggs and identifying information about him, and then also it's very relevant to the enhancement that we have charged.
All right. Thank you. Anything further before the court rules on these two requests? All right. In reviewing the first section, again, citing to page 10, and I know it is, to anyone listening, this may not make sense when I'm saying page 10, but it's roughly just a few seconds after 1539 on the video, starting with "was he," and ending at 1646 with the last word "asking." After hearing and considering what has been argued, the court agrees that this, in applying a balancing test and as it relates to transparency, to ensure the court is taking a very narrow approach in what is or is not published to the public, that this is permissible. It doesn't run afoul of the issues that the court addressed previously, that the court is trying to avoid by publishing portions. And in addition to that, independently of the court's decision-making, it appears that the parties also agree as it relates to the first requested edit to unredact or to allow in. So I am ruling that that may be played and published through all mediums in the courtroom and via video. Turning to the second section, this is page 19. It is roughly right after 3327, going to just before 3340.
Sorry, Your Honor, just to clarify, what we asked was just before 3307.
3307?
Correct, yeah. Yes. Right after 3255, where
All right.
Mr. McBride states, "Okay."
I see, thank you. Let me just take a quick second to review this. In relation to that request from right after 3255, starting with "okay," is that the spot you're talking about, Mr. Ballard?
Yes, Your Honor.
All right. And specifically to 3327, the court stands by its original ruling. That is not, there are several reasons why the court, the court's ruling isn't whether it's relevant or not. It's whether it should be published or not. And again, as previously stated, the entirety of Exhibit 16, the court is receiving without any redactions or edits. The court is considering it as it weighs probable cause. However, for publication, the court finds that the requested section from roughly after 3255, starting with "okay," ending at 3327 is, the court finds that there are interests served by not publishing this to the courtroom or to be broadcast. I note and I recognize Mr. Novak's statement as it relates to what Mr. Twiggs' counsel may or may not assert, but the court finds independently that this this portion shall not be transmitted into the courtroom because of certain statements made in there that do not serve the interests of justice for publication. However, the court finds from 3327, starting at OK, until just before 3340, I'm sorry, up to 3340 may be published. Did that notation make sense?
Did to the state, Your Honor.
All right, to defense.
Understood.
And so this is the appropriate balancing of being transparent while at the same time maintaining the constitutional rights or balancing the constitutional rights of all parties and what is appropriate for publication. And this may be published not only to the gallery but to the media as well, that goes beyond the gallery itself. All right. Anything further on State's Exhibit 16?
Not from the state, Your Honor. Thank you.
All right. And I note defense is nodding their head as well and not indicating any more is needed to be discussed at this point. All right. I think we've put State's Exhibit 16, we've addressed it. Turning to the state.
Thank you, Your Honor. We would just like to briefly emphasize a few points in the briefing that we filed early this morning. Last night, the defense raised the issue of publishing admissions by the defendant or confessions. They cited to one sentence from the United States Supreme Court opinion in Estes versus Texas that relies on the Rideau versus Louisiana case. And that one sentence in Estes has no precedential value on the issue that's before the court today. Estes cited to the dissenting opinion in Rideau, which is very curious because that dissenting opinion, Rideau was a change of venue case, and what the dissenting opinion held is that the court properly refused to change venue in that case, even though the defendant's confession had been televised multiple times. So it's puzzling that that's what the Estes court would rely on as supposedly constructing some kind of rule about publishing a defendant's admissions. In addition to that, Estes has no analysis of that point from Rideau. Again, it's just one sentence, and Estes itself was a case about televising a trial. It wasn't about pretrial publicity of a defendant's admission or confession. And as we noted in the brief, subsequently, the Supreme Court has limited, although it hasn't expressly overruled Estes, it's limited that case to its very narrow facts. So it's difficult to see what precedential value that one sentence from Rideau could have on this issue before the court. Even if it could have some applicability here, the circumstances in Rideau are starkly different from the circumstances here, the statements, the types of statements from defendant that we're talking about. In Rideau, what the police did was orchestrated a recording of an uncounseled, unmirandized police interrogation. The Police recorded that interrogation. It was leading questions. They recorded the defendant answering those leading questions. And then it was the police that immediately released that recording to the press, who then publicized and televised that. The defendant confessing to police, answering the police's questions. That's not the types of statements that we're dealing with in this case. What we're dealing with are statements that defendant voluntarily made to close friends and associates of him and his roommate. Sorry, just one other point about Rideau and that dissenting opinion. It's interesting that in that dissenting opinion, that judge that the court relied on in Estes continued on in his opinion and said it's an impossible standard to require that a trial court be a laboratory that's completely sterilized and free from any external factors. So again, it's hard to see how Rideau has any precedential value, and even if it did, the circumstances are completely different than the types of statements that we're dealing with here. The state has also cited to several other courts that have easily distinguished Rideau and have made it clear that there is no blanket ban on publishing, especially just in court, a defendant's voluntary admissions. I think the most interesting case is the Sixth Circuit case, because there it dealt with essentially the issue that we're dealing with here, which is publication of a defendant's statements during a preliminary hearing. And that case is especially important, the DeLeslie case, because there that confession was ultimately held to be inadmissible. So an inadmissible confession was played to the public and interested media members so that in a way that it had, as if it had been played in a preliminary hearing. And even though that confession was subsequently publicized and ultimately held to be inadmissible at trial, the court did not hold that that was a violation of the defendant's fundamental rights there, that the court could deal with that through voir dire. It was not inherently prejudicial. And then the state has also cited to the Ohio case of Mamon, and then also the Alabama case, Burgess versus State, where those courts reached essentially the same holdings, easily distinguishing the Rideau sentence from Estes and making it clear that there's no blanket ban on publishing a defendant's admissions, and also that Rideau is easily distinguishable. And because the court can deal with those pretrial publicity issues in the way that we've discussed several times already through the tools that the court has available in selecting the jury. I think it's also important to point out that transparency is critical in this case. This court's noted repeatedly the extensive media coverage. That's why we're having to take this additional time in these hearings to be able to discuss these issues. And transparency is critical to the state's right and the people's right to a fair trial. Where there's a vacuum in the evidence, it just fuels speculation. And then finally, as has already been argued, it's critical to the victim's right to be able to attend the hearing. That's a hollow promise if the victim representative is only able to be here physically, but then is shielded from some of the evidence. Does the court have any questions?
No, not
Thank you.
not this time. Mr. Novak.
Thank you, Your Honor. The parallel between Mr. Robinson's case and the Rideau case is this. Mr. Rideau's confession was televised by an act of the state. it wasn't a confession broadcast through a courtroom. It was a confession made to law enforcement and then broadcast by action of the state. And that's what gives rise to the constitutional problem, which is its state action, which violated Mr. Rideau's right to a fair trial. This court has granted the media's request to electronically publish this entire proceeding. That's state action. And the state has supported the media's request over Mr. Robinson's objection. So that is also state action. So that's the parallel. If there were no cameras in this courtroom, we would not have a problem. And in fact, Ms. Kirk's attorney's briefing seeks a remedy which has nothing to do with the cameras in the courtroom. What Ms. Kirk's counsel seeks is the opportunity for people in the courtroom to see the evidence. So the state is going even further than Ms. Kirk's counsel. The state wants to publish what it calls confessions in the same way, essentially, that the state published Mr. Rideau's confession. Now, the only other thing I want to talk about is that Mr. Ballard's correct that the blanket rule that there is unrebuttable prejudice that's stated in Rideau. We could talk about why dissenting judges say, oh my God, the court has established a rule and I don't like it. That's what's going on there. But it was in the Skilling case, a Supreme Court decision in 2010, where the court said, yes, we really are going to let judges decide whether potential juror exposure to pretrial publicity makes them unable to serve. But there is an extreme case. That's not my language. That's the Supreme Court's language in Skilling. There are extreme cases of pretrial publicity where prejudice is going to be presumed. And so that's obviously about what has to be proven in terms of the prejudice. But when it's an extreme case, what the Supreme Court is saying in Skilling is there's a presumption. And I believe that this court has already made findings over the last 9 months that this is an extreme case with respect to the quantum of pretrial publicity, the way in which it's being monitored by the public, the speed with which these proceedings, even this week, are being dissected and broadcast through all of the technology channels that we have. So it's our view that this is the extreme case that the Supreme Court talked about in Skilling. We wouldn't have any state action giving rise to this problem if we didn't have cameras in the courtroom. And that's why we think that Exhibits 16.1, 16.2, and 16.3 need to be managed in the way we've asserted. Thank you, Your Honor.
Thank you. Mr. Ballard.
Thank you, Your Honor. Just briefly, Mr. Novak's misrepresented the state's position. We're not going beyond what the victim representative has asked for. As we made clear in our briefing this morning, that we filed this morning, we are asking that these exhibits, unredacted, be published in the courtroom. Not electronically, but they be published in the courtroom. It's not the camera in the courtroom that's the problem. The issue here is the public's right. This is a public hearing. The court's ruled that it's a public hearing. Kearns Tribune recognizes that preliminary hearings are public. And the public that is here in this courtroom should be able to see the exhibits that are admitted and that the court is going to rely on. And that is even more important to the victim representative's right to be able to be present and to observe these proceedings. Thank you.
All right, counsel?
Your Honor, if I may, I'll be brief. I want to begin by saying thank you to both the parties, to the state, to the defense, to the court. Today, the time that's being taken today and the nimbleness that's required to talk about things like a transcript in open court is a challenge. I recognize that it presents difficulties and that it takes time. And I want to begin by thanking both the parties and the court for taking the time to do that. It's important to the public, and I appreciate the court doing that. I know the public does as well. The only thing that I want to say with respect to this question about admissions or confessions is something that I hope will help the court. The court is looking at Rideau. It's looking at Estes. These cases from 50 or 60 years ago in a different media environment under the United States Supreme Court. I want to urge the court to do what the court has done before, and that's to look at Algier. This is a 2011 Utah Supreme Court case. It's obviously in the wake of Rideau. It's obviously in the wake of Estes. It's here in this state, unanimous Utah Supreme Court, upholding a decision made by Judge McCleve below in a case that has striking parallels to this one. In the Algier case, there was a murder trial. The court received a letter, a notarized letter from an inmate saying the defendant in this case has confessed to me. Told me that he was involved in the shooting, gave me details of it, threatened me and my family if I did that. I want the court to know that. That was provisionally sealed for many of the same reasons that the court could conceivably consider keeping some of this information from the public. The court did a two-step analysis. It began by trying to determine whether or not there was a presumptive right of access to that document. The answer is yes. There is a presumptive right of access to this proceeding as well. Like Mr. Ballard just said, because this is a preliminary hearing, there's a presumptive right of access for the public. The second question was simply whether there's some kind of balancing that should be done. Notably, in paragraph 17 of that Algier case, it stressed something that we have said over and over again, which is much of the information that would be revealed through that letter had already become public at that point. And the idea of sealing a document that contained allegations or details that were already in the public sphere would only create the impression that information was being kept from the public when it was not. We stress what we did yesterday, that as we understand it, much of the information that is now under consideration for the court is already in the public sphere. The right case to analyze this under is Algier. Algier would dictate in this case that the court recognized there's a presumptive right of access to this material, and that the presumption, the balancing test that would be needed to overcome that presumption of access has not been satisfied here, particularly because so much of that information is already in the public sphere. That must be an animating factor here, and we ask the court for that reason to grant access, both publication to the courtroom and, in our view, publication on the cameras as well. But we again do recognize that that middle step is a meaningful one. And if the court were to decide that that information be shared in the courtroom but not on the general feed, we would recognize that as well as a meaningful step towards transparency in this case.
Counsel?
Good morning, Your Honor. Jeffrey Nyman on behalf of the Kirk family. And we appreciate the court is trying to balance here, but the Kirk family's waited 10 months for this hearing. And they have a right to be here, and they have a right to hear the evidence. They have a right to see and feel what's going on in this courtroom, just like, and they want to understand, Judge, what you were viewing. They want to see the evidence. And we understand you have to balance, but at a minimum, this courtroom needs to be open for the evidence to be displayed openly in this courtroom, for them to see it. The Utah Constitution gives them the right to be here, and to be here and not to see the evidence, what's the point of being here? We ask you to let the evidence be seen in the courtroom, please. Thank you for your time.
Thank you, counsel. Anything further as it relates to exhibits 16.1, 16.2, and 16.3 as it relates to what's been briefed or any other arguments? I just want to make sure it has all been received before the court issues its ruling.
No, thank you.
Not from the state, Your Honor. Thank you.
All right. And just to be clear, as it relates to the state's request, 16 point, well, so under the three factors, or the three levels, admission to the court, publication to the gallery, and then publication beyond the gallery. What is the request for each of these exhibits?
We are asking, we, Your Honor, we are asking for admission. We are asking for publication within the courtroom, but not publication electronically on to the electronic coverage in the courtroom or of these proceedings. We do want to make clear that once the exhibit is admitted, that the witness will be reading from portions of the exhibit, but again, we're not asking that that be displayed in any way so that those outside the courtroom could capture that and reproduce it.
Thank you. The court just wants to. And just for clarification, 16.1 is the text messages, 16.2 is Discord chats, and 16.3 is photograph of notes.
That's correct, Your Honor.
All right. And finally, and this hasn't really been addressed by any party, but it is a factor the court's weighing, how much of 16.1 has been published to the public prior to these proceedings? And this is open to all if you wish to weigh in. I just want to make sure that that's clear because that wasn't really addressed in the briefing and it's a factor. So I want to make sure that that issue has been presented by the parties if you choose to.
Your Honor, with respect to Exhibit 16.1, some of those text messages do appear on pages 8 and 9. Pages 8 and 9 of the information that is public.
Could you give me a rough estimate or percentage of how much of the total amount of 16.1 appears not in the information? Again, I'm just trying to create a record of what is out there from your perspective so the court can consider that in its analysis.
Your Honor, State's Exhibit 16.1 is 18 pages total of photographs of text messages. It's approximately 5.5 pages of those 18 pages that are reproduced in the information. Thank you for your patience.
Thank you, Mr. Ballard. I appreciate you doing that on the fly. Anything further from any party? To defense?
No, thank you.
To the prosecution?
No, Your Honor, thank you.
Media?
I'll just point out for the court that in addition to the text messages, I believe, I haven't seen the other exhibits, but I believe that at least the note itself, which is another one of the exhibits, is also described in the information.
Thank you. Ms. Kirk's victim representative attorney.
This has not been easy, as you can imagine. And I think the family deserves to see the evidence that's been gathered in this investigation. They deserve to know what happened to Charlie. So we urge the court to please, again, display the evidence here in the courtroom.
Thank you. Thank you to all parties. I appreciate the diligence and hard work that you've put in briefing, argument. These are important exhibits as it relates to what should be considered for, again, to be clear, these exhibits are being admitted to the court in its entirety. The question before the court is publication within the courtroom and beyond the courtroom. And so this is the ruling as it relates to the briefing, and I know it wasn't a formal motion, but I'm just trying to be thorough in my approach. This matter comes before the court on the state's request to publish Exhibits 16.1, 16.2, and 16.3 during the preliminary hearing and defendant's objection to that request. The exhibits consist of text messages between Mr. Robinson and a witness, Discord messages between Mr. Robinson and others, and a written note the state attributes to Mr. Robinson. Attorneys for Mr. Robinson argue the publication of the exhibits during the proceedings subject to electronic media coverage would create a substantial risk of prejudice and impair his rights to due process under the 14th Amendment. The defendant relies on Rideau versus Louisiana, Estes, and Skilling, and asks the court to consider any admissible exhibit for the purposes of the preliminary hearing while limiting their public display or broadcast. The state responds that Rideau and Estes do not require a categorical restriction here. The state argues that the exhibits are materially different from the televised custodial interrogation at issue in Rideau because they are written communications allegedly made outside law enforcement custody. The state also argues that the potential prejudice can be addressed through trial management measures, including voir dire, and that the victim representative has an interest in being present for and able to follow important criminal proceedings. The court has considered the parties' arguments, the nature of the exhibits, and the procedural posture of this preliminary hearing, the defendant's due process interests, the public nature of the criminal proceedings, and the interests asserted by the state and victim representative. On the present record, the court is not persuaded that the publication of Exhibits 16.1, 16.2, and 16.3 during the preliminary hearing creates the type of inherent or presumed prejudice that requires categorical restrictions under Rideau, Estes, and Skilling. Unlike the broadcast interrogation in Rideau, the exhibits at issue are written communications allegedly made outside police custody and are being offered in the ordinary course of a judicial proceeding. That distinction does not eliminate the possibility of prejudice, but it weighs against treating publication of the exhibits as presumptively unconstitutional. The court further finds that any potential prejudice arising from media coverage may be addressed, if necessary, through the appropriate trial procedures, including voir dire and any other measures warranted before trial. This ruling is limited to publication of the exhibits during the preliminary hearing and does not determine their admissibility at trial, and I insert if one occurs, or foreclose any later request for relief based on a more developed record. Accordingly, the defendant's objection is overruled. As it relates to this preliminary hearing, the state may publish Exhibits 16.1, 16.2, and 16.3, and the court is authorizing, with the exception of the third to last page on Exhibit 16.1, because it contains information including a phone number and address to be redacted before publication in the courtroom. But as it relates to 16.1, because it was publicly distributed by the state, that 16.1 in its entirety may be broadcast through electronic media. That is the ruling of the court. Counsel, how would we like to proceed?
Your Honor, just to clarify the record, the state has redacted that portion. We anticipated that needed to be redacted in 16.1, so we have redacted that portion. We believe that the best way to proceed now is we have the edited video ready that comports with the additional edits that the court has ordered. We propose that we take a break so that we can show that to the defense, make sure we're on the same page, and then we anticipate coming back and playing Exhibit 16.
All right. Okay. All right, I appreciate the caution.
To do, and then the exhibit was brought onto the screen. I reviewed the video last night. The camera captured this for approximately 2 seconds. The camera operator, I think, acting in diligence and appropriateness, immediately panned as soon as she realized that there was a new exhibit on the screen. The court took it down, and as soon as they realized that an exhibit was on the screen, I immediately instructed my paralegal to take it down, and it was. Defense, I think everyone involved here made quick and appropriate efforts as soon as they realized a mistake had been made to remedy and mitigate that issue. As I explained what I was what we were going to do, defense counsel did not object as that happened. And the reason I bring that up is because of the requirement for timely objections. Moreover, I do want to say this exhibit was read into the record. It was allowed to be read into the record earlier. It is also in an earlier pleading, which is the information. This portion of that exhibit, I understand, is in the information. And it is largely cumulative of Exhibit 16 and 16.1, which were previously admitted into evidence and published to the media. Finally, we are going to be dealing with a lot of publicity when it comes to media coverage, and I think that's really where the remedy is going to be addressed. I understand there may be a remedy that can be fashioned today to prevent this kind of thing going forward or going on in the future in this hearing, but I think ultimately that's where this will be addressed. Any other questions from me, Your Honor?
Well, not at this time. I will afford you the opportunity, obviously, to respond when the defense comes back. I want to weigh this in taking in consideration, and I find your representations to be accurate as to what occurred. I believe that I noticed it and asked for it to be taken down because I have a live stream on my screen for that very purpose. And the sequence, I believe I made note, and if I'm wrong, please correct me. It's been a long 4 past days, but that's the only addition that I find to the representation. And certainly, Mr. Novak, feel free to correct it if you believe the sequence was any different. I just want to make sure a clear record is being made of what happened in order for whatever happens next to be appropriate and proportional to the actions that occurred.
No, and that's consistent with my memory, and I also reviewed the video, the live stream as well, in preparation for this issue today. So that's exactly what I think happened. From my perspective, examining the witness, I did not have a view of what was being published to the public and the media, and so I think the court immediately, as soon as it recognized that, brought that to everyone's attention.
Thank you, Mr. McBride. To the media.
Good morning, Your Honor.
Good morning.
Appreciate the opportunity to be here to speak on behalf of the media. I think our understanding of what happened is consistent with what both the defense and the state have said here. So I don't want to belabor that point. But here's how I understand them. There's two exhibits at issue. Those exhibits were used yesterday in part because the juxtaposition of those two exhibits might have provided some sort of benefit to the court. The first of those exhibits was asked to be published through all three of the court's phases. The court said it will be admitted into evidence, be shown in the courtroom, will not be shown on the cameras. That happened about 3 hours into the hearing. That all went smoothly and well. That operated exactly as it is intended to. That requires the participation of everyone, the court, the defense, the state, media, camera operator, all to do that well. Later in the day, when in the video I reviewed, this was about 5 hours into the runtime yesterday. The second exhibit that was going to be compared side by side was introduced. That also went through that three-step process. In that case, the court said that that could be admitted into evidence, shown to the court, and then also shown on the cameras. So it was put on the courtroom cameras. At that point, there was what I think is a useful practice by the camera operator to wait a beat, because sometimes mistakes do happen, right? In that case, though, that was authorized. So the camera then panned to the screen, which is set up specifically for the camera operator to be able to capture that. Examination on that exhibit began. Then, because the examination seemed to call for that juxtaposition, without much warning for anyone involved, the previous exhibit that was intended to be juxtaposed was placed on the screen. From, I think, a observer's view who didn't know where the testimony was going without warning. The camera operator, I think quite astutely, within seconds, recognized this is a different exhibit, and recalling the court's prior order, recognized I should pan off, and did within seconds. I think at the time that was happening, the court also caught that and said, let's not do that. Now, and that was the end of it. I think the 2 seconds is about right. I don't want to minimize that. I understand the point that Mr. Novak is making. We are operating in some ways on high wire. And we are trying to place as many nets as we can, and all the parties are working together to try to do that. But in the age in which we live, one of the challenges is that sometimes when something like that is placed on a live screen, someone can screenshot it, and like Mr. Novak said, if they want to put that for sale on the internet, then they can. That's why working together to ensure that even small mistakes like that don't happen is critical. And the media has the media coalition that are given the opportunity and the benefit of being able to be here to run cameras and to take photographs have complete buy-in on that point. There are, of course, people out there watching a live stream that are not part of our coalition that we can't control, and that's why it's so important that we get these pieces right. I do want, without going too far into the evidence, to note not only that several lines of this exhibit are available publicly in the information, but that the full text, every word, of that exhibit is contained in a search warrant, in this case, that was initially filed on September 17th. This is in the 4th District, but in a different court. Was held for 6 months, as search warrants often are, but then on March 17th, March 16th, March 17th, was released in full. On page 7 of that search warrant is the full text of this exhibit. I don't want to suggest that anybody gets the right to say, well, I think it's public. The court has said don't show it in the screen, but since I think it is, we'll just come back later on and tell the court it's not a big deal because it's already public. That's not how it works. If we say we think it's in the public, the court says, I understand that, but I'm going to make an order. That order should be adhered to. But I do, for purposes of prejudice, for potential remedy, for the court's concern and the court's sleepless nights, I do want the court to know that as well. And members of our coalition have pointed out to me as we've talked about this, while we take this very seriously, it is true in this case that the full text of that, not the image of the exhibit itself, but the full text is already in the public sphere, has been reported on, and is out there. I only want to reinforce, to close, the recognition that the media, our coalition, I, as an attorney for that coalition, have an obligation to make sure that mistakes don't get made. And in this case, even though I believe that the camera operator didn't act in violation of the court's decorum order, didn't do something that was forbidden by that there was an order that said, don't publish this exhibit, And because it flashed on the screen when the camera operator was filming that screen, that did happen. The media is fully bought in. I, as one of the attorneys and the other attorneys for the Media Coalition, are fully bought in on a goal to make sure that this kind of thing doesn't happen. Of course, I understand Mr. Novak and the defense's need to make a record and make an objection, and I also recognize and appreciate and understand the court's role in trying to make sure it imposes whatever sort of direction, caution, sanction, response that it believes is needed to make sure that its orders are recognized and adhered to. And I want the court to know that we will understand that and will comply with whatever it is that the court orders.
Thank you. Anything further before we break? Mr. Novak?
We don't need a break.
Okay. Well,
The court wants a break.
I want to review this. I'm sure there is a stream out there. I want to look at it again in order to appreciate the full effect and exposure. I remember it, but given the nature of this and trying to weigh the constitutional rights of all parties, I want to be thorough and look at it exactly. So as we move forward, as I evaluate what's being requested by the parties, that I am at the level of knowledge, and because for what it is, it was on screen. I want to look at it, how long, what exactly was on screen, and in order to be at the point of saying, okay, I fully understand. I mean, I was here, I saw it, I noticed it on the screen, but again, I want to take that extra 2 minutes to review that.
I am not suggesting that we rush through this at all. I just wanted the court to understand that our request for the remedy and the sanction, we are prepared to share that with the court, but we can certainly wait until the court has had an opportunity to review whatever the court thinks it needs to review. The permanence of this violation of the court order is a different issue from how long it took to correct the violation. It's a permanent consequence. In other words, that image is out there forever and ever in violation of the court's order, no matter what actions the court, the state, and the media took to remedy it, because that's the technological world we live in. So that's my response, if I may, to the arguments. But we can hold our suggestion until the court's ready for it.
All right. If the parties feel it'd be helpful to confer while the court is reviewing it, you may, just so that if you choose to, I encourage it. If you don't, I respect that. A court's going to take about 5 minutes. Again, I just want to review it, to be brought up to full speed and just to have it freshly in my mind.
I'm going to make one more point, if I may, and that is this is not the first time that this has happened. We had earlier proceedings in this case where the cameras depicted images inside the courtroom that the court had prohibited, and the court imposed certain consequences on the media as a result of that. And so that's just something to keep in mind, in my opinion, if I may. Thank you.
All right, before the court takes a 5-minute recess and to review this, does any party need the benefit of the record based off the dialogue between me and Mr. Novak? All right, not seeing any party respond. The court's in recess. We'll come back at 9:45. Or use of a cell phone in the courtroom may be addressed by the court. For those individuals who are authorized to have a cell phone, please place your device on silent at this time so that these proceedings may continue without interruption. The court also expects that every person in attendance will be treated with the dignity and respect to which they are entitled to. Consistent with the court's standing decorum order, all spectators shall remain quiet, civil, and orderly at all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or other visible reactions during their hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or in opposition to any person connected with this case or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, orderly, and faithful to the rights and dignity of every person involved. Finally, I wish to note that this preliminary hearing is scheduled to conclude this Friday at 5 p.m. I raise this as simply a reminder for the parties, particularly given that we have now reached the midpoint of this week. I recognize and respect the constitutional rights of all parties. When this preliminary hearing was set, the court allocated a substantial amount of time for both sides to address the matters they consider necessary and appropriate for purposes of this proceeding. The standard at a preliminary hearing is probable cause, and with that in mind, I ask counsel to remain mindful of the time that remains and manage your time appropriately so each of you is able to fulfill your duties to your respective clients within the time frame that has been provided. And with that, I wish to inquire of a brief overview on what is anticipated from each party in order the court has a roadmap on how we are proceeding for the remainder of this preliminary hearing. First, turning to the state, and if you wouldn't mind coming forward, Mr. Grunander.
Thank you, Your Honor. We anticipate presenting evidence through Agent Brian Davis this afternoon. Sergeant Jennifer Falmina is also present in the courthouse and prepared to testify if we get to her today as well. Following her testimony, which we believe will carry into tomorrow, if we do get to her today, that will close the presentation of the evidence on the part of the state.
Thank you, Mr. Grunander. For defense.
Good afternoon, Your Honor.
Good afternoon.
Michael
Mr.
Bird for Mr. Robinson. Judge, we have two remaining witnesses, Miss Oliver from the ATF and Miss Carner, also from the ATF.
All right, and to both parties, thank you, I appreciate that. Do both parties anticipate any issues concluding their case? Obviously, there's variables, cross-examination, and kind of the fog of war that happens in court proceedings, but any party anticipate issues concluding at or before Friday at 5 p.m.?
Not from the state, Judge.
Just want to highlight one issue for the court because it may be that the court wants to do some time management. The state is going to proffer a video 1102, a video recorded 1102. We have provided the state, I want to say about a day and a half ago, with proposed redactions because we believe that portions of it are not admissible, even in a preliminary hearing. And the way we did that is we provided a transcript and then a redacted version of the transcript of the entire video recorded interview. It may be that the court wants to look at the proposed redactions not while court is in session, but during some other period of time, because the transcript of the video, which we prepared and we provided to the state so the state could raise any concerns about the accuracy of the transcript. That's not an issue. The admissibility of portions of the video or the issue is about 20 pages, maybe 22 pages. So to use court time for the court to look at the proposed redactions may be an inefficient use of the time. I'm not saying when the court should do it. I'm just saying we may not want to do it between 9 and noon and 1 and 5 tomorrow or Friday. But it's going to come up today, and so the question will be, when does the court want to engage in the process of reviewing a 22-page transcript that has proposed redactions? That's all.
I appreciate the heads up. Mr. Grunander, do you wish to be heard?
Yes, Judge. Your Honor, the state has received the proposed redactions, and we are prepared to address them when that time comes. However, we do intend on presenting testimony through Mr. Davis, through Agent Davis, and when we get to that point, when it's ripe for discussion, we can address the matter with the court. That would be our preference.
All right. Well, I'll address it as it comes. And to the defense, with the remaining time, do you feel confident that it is sufficient to accomplish your duty?
We do, Your Honor.
Thank you. All right, does either party require the benefit of the record before we begin? To the state.
Ryan McBride for the state, Your Honor. Just to address an issue that's come up and we expect to come up as we enter the second half of this preliminary hearing regarding the admission of exhibits. Under Rule 104A, the court must decide preliminary questions about whether the witness is qualified or a privilege exists or evidence is admissible. In so deciding, the court is not bound by the rules of evidence except those on privilege. And I'm bringing this up again because it's likely to come up and it is going to affect the procedures we use as we go forward. The court holds two roles, really, at this stage. One is a gatekeeper role on admissibility, and the second is the fact finder role as the magistrate. And I know you've referred to those two roles earlier in this proceeding. And the court, Rule 104A means the court can consider evidence even though its admissibility has not yet been determined in its gatekeeper role. And then, after it has been admitted, it can determine the admissible qualities of that evidence or that exhibit. And that is especially relevant at a preliminary hearing where foundational evidence is reliable hearsay under 1102b3. Even at trial, State v. Griffin, which is a 2016 UT 33 Utah Supreme Court case, the court has held that rules of evidence do not apply to evidence used to establish foundation for admission of other evidence. It's a quote from paragraph 33. So the point is, foundational rulings on admissibility can consider evidence that is not in and of itself admissible. That's proper. The second point is the courts of appeals recognize a presumption that the court considers, when acting in its fact-finding role, only the admissible evidence and disregards any inadmissible evidence. Most commonly, that comes up in a bench trial type case where prior bad acts evidence is admitted and it can have dual inferences. State v. Adams was one of those cases. That's 2011 UT App 163. And what it means is we know that a fact finder is not tainted by the judge's role as a gatekeeper, even though the judge as a gatekeeper considers potentially inadmissible evidence. It also means that the court doesn't have to distinguish which hat it's wearing as we go through the proceeding. In this circumstance, this hearing is taking place outside the presence of the jury. The state has laid and intends to lay and continue to lay foundation in open court. Such foundation sometimes will include discussion of the actual exhibits rather than just proffers, as well as foundation for the exhibits. Now, I don't think that there's any issue between us and the defense in understanding that kind of statement of the law. I think the issue that has come up is under Rule 104B, determinations of admissibility take place outside the presence of the jury. The defense appears to be assuming the jury to be basically the potential jury pool and trying to avoid the potential taint to a jury pool that discussion of evidence, which may or may not be admissible, may cause. I think that's a fair point. I just want to put the court on notice of our view and how we have and intend to proceed as we move forward. Under 104B, that determination takes place outside of the presence of the jury. Under the rules, there's a presumption that these hearings and this hearing is open to the public, including admissibility hearings. Because of that, we intend to move forward and move the admission of evidence and argue the admission of evidence as in open court. Should the court close the hearing, of course, that would change. But that's because that's the presumption in the law, and that conforms with 104B. That's our intention, unless the court or counsel moves to close the hearing. So, in summary, the court can and often should consider evidence and review the exhibits before admission. 2, the court is not tainted by doing so, and can distinguish between admissible evidence and improper evidence. And there's no need for the court to identify which hat it's wearing. And 3, absent closure, we'll move forward with our evidence in open court.
All right. Well, I'll hear from defense if you want to be heard on that issue. I see you, okay.
Briefly, Your Honor, I'm sorry I have two microphones. I'm just trying to be technologically savvy. I think the 104 issue, I agree completely with Mr. McBride on what he's saying. Because of the Supreme Court's ruling in Archuleta concerning the availability to the public of exhibits from a preliminary hearing, which of course is a fact-specific inquiry by this court, we will continue to raise concerns about our client's right to a fair trial when we think it's appropriate, and the court will make the rulings it makes. That's all I want to say.
All right. All right, to both parties, the standing request remains when you are moving a piece of evidence into to the record, I ask 3 steps. Admissibility, to admit it, to be published in the courtroom, and then to be published on that screen. And I'm going to have the screen adjusted slightly because I want, if it's published, I want it to be meaningfully able to be viewed. And I noticed somebody sent me a screenshot that angle creates an interesting angle that kind of distorts it. So in the interest of, if we're going to be transparent, it should be viewable transparent. So we'll adjust that screen briefly, but please address those 3 issues. And I understand one side or the other might say, well, we agree or we don't agree, period. But please, I'm trying to make sure that the record before us is a clean and clear record. So if you would do that, the court would appreciate that. All right. Anything further?
No, Your Honor.
All right. The court acknowledges that the exclusionary rule is in effect. At this time, any witness who is subject to exclusion should be excused from the courtroom. I will leave it to the parties to monitor the courtroom to ensure that compliance is adhered to. With that, turning to the state, you may call your next witness. Yes, I mean, I want the press to be able to see it too, but when it's, there is a bit of a distortion when it's at that particular angle. So while the parties are moving forward, go ahead and adjust it, and let's put a sample image of something that has nothing to do with this case on the screen.
Judge, that's another issue. I don't know that it is projecting yet. And I don't know if we need to take a break to make sure that's working.
Is it not projecting on the monitors? Okay. Technology is challenging us again. Well, what's our thought, staff, on projecting? Is this something that's not going to be cured by turning off and turning on, I'm assuming?
I just need some other tables besides 3 so we can try.
All right, if you, all of you, council table, again, I'm trying to do this to get this out of the way so we can move forward cleanly. If you wouldn't mind turning off your monitor and then turning it back on, and if I could borrow somebody to do that to the witness monitor as well, so we all get them in sync. Thank you, sir. I appreciate that. And for the lectrum as well, let's just see if we can get that up because that could cause a delay. I just want to knock this out first. Yes. Where would that TV go? If that doesn't address any security issues, let's do that. I just want to make it easy. That way that TV can be more flat and it's not a distorted view, and then the media can look at that TV. Again, transparency needs to be viewable, not just there in concept. All right, yeah, let's go ahead and do that. How are the monitors looking? Nothing? All right.
I need them to actually plug in their HDMI.
I see. Could I have someone with your laptop plug in so we can test, so we can check if it's receiving the data or the information from your laptop to allow us to project? That may be the issue.
Mr. Ellis is plugged in.
All right. Let's take a look here. I appreciate the parties' patience, especially after I just said we're at the halfway point.
We're getting a thumbs up.
All right, so it's displaying for defense, for prosecution.
We're working on it right now, Judge. Yes.
All right, and on the screen monitor here, it looks like something came up. All right, we'll just hope that the monitor for the witness works as well. All right, so we're ready to go? Just bring it in and go ahead and we'll get started. And how much time is needed for that? Well, let's go ahead and proceed, and then when we take a break, then we can do that. But for now, the media, if you can see that TV, if you have any problems, please let me know. And we're going to bring in that second TV. We just want to get the train on the track here. All right, Ms. Hunt.
The state calls Agent Brian Davis.
Agent Davis, if you would like to come forward and be sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
All right, Agent, if you wouldn't mind having a seat. To your left is a water bottle. And after you're seated, you'll have to adjust that microphone, pull it down, and then pull it toward you to ensure that it is picking up your voice and we have a good record. All right, Ms. Hunt, your witness.
If you could please state your name and spell your last for the record.
Yeah, it's Brian Davis, Davis.
What is your occupation?
I'm an agent with the Utah State Bureau of Investigation.
How long have you been with, is it fair to call that SBI?
Correct, yes.
How long have you been with the SBI?
A total 18 years.
I want to briefly go over your experience as a law enforcement officer generally. Actually, are you a law enforcement officer in that capacity?
Yes, correct.
How long have you been a law enforcement officer?
A total of 27 years.
You mentioned you were with SBI for 18, is that right?
Correct, yep.
What other agencies were you with prior to SBI?
So Department of Public Safety, I've been a state trooper for 8 years, 18 years with SBI, and 1 year with Utah Transit Authority Police.
We've heard talk from other officers about POST. What is POST?
That's Peace Officer Standards and Training.
Did you complete that?
I did.
What year did you complete that?
1999.
Is that a type of certification that you hold?
Yeah, it's a statewide certification that any peace officer in the state of Utah, local, state, county, all go through to become a certified peace or police officer.
Has that certification lapsed or been any gaps in that time since you received it in 1999?
Nope, it's been constant since then.
I want to talk about a bit about your training and experience within law enforcement. What roles have you had at SBI?
I began as a alcohol enforcement team. We did covert and overt operations. I was assigned to an ATF, the PSN task force, focusing on violent felons with guns and drugs. I was on a FBI task force, Safe Streets. It was a gang violent crime task force. I was on the U.S. Marshals Fugitive Apprehension Team task force. I've been on several different OICI protocol teams, officer involved critical incident teams around the state of Utah and within SBI. I've been on dozens of those scenes. And within major crimes of SBI, I've been, we've worked a variety of cases. I work anything from violent crime, homicides, sex crimes, drug crimes, firearm crimes, white-collar crime, fraud. I was also on a task force with a FBI public corruptions task force as well.
Was that all on-the-job training, or did you receive specific training or conferences, things like that?
Yeah, throughout the years, various trainings, conferences for in all those capacities over the years.
You mentioned you've been a part of homicide investigations.
Yes.
Can you estimate how many?
My best guess would be 60 plus, where I've had some involvement. I also currently work on a cold case unit within SBI, so we consult with agencies around the state of Utah, and I've probably consulted on over 50 of those as well. in various capacities and roles.
Have you received training specific to homicide investigations?
Yes, I have.
What types of things have you been trained on in that regard?
Just several different times, week-long course training conferences on homicide, from case studies to how to manage a case. Also, I've been on several trainings with like crime scene investigation. I'm a Faro certified. It's a 3D Faro scan of crime scenes.
What's a Faro scan?
It's a 3D laser imaging that's used pretty commonly on crime scenes. It just accurately documents crime scenes. I've been on, I'm been certified as a forensic interview and the forensic interview technique with more child victims. So just various trainings like that.
You mentioned currently you're a part of the cold case team within SBI.
Correct.
Have you been assigned as part of the investigation into the homicide of Charlie Kirk?
Yes.
And what is your role? Do you have a specific role in that investigation?
Yes, I was assigned to be a case agent along with Agent Dave Hull.
What does it mean to be a case agent?
Essentially, you manage the case, responsible for it. Ultimately, you direct the cases as you go along. You make assignments as needed. Ultimately, everything comes back to you, like in the form of reports, evidence, and such. And then ultimately, you screen that case, if applicable, to the appropriate county attorney or DA.
You mentioned that you are a co-case agent or were with Agent Hull. Is it typical to have two case agents on a case?
It can be especially on a large case, yes.
Has this particular case been large?
Yes, it has.
Have other police agencies been involved in the investigation of this case?
Yes.
Who has been designated as the primary investigative agency?
The State Bureau of Investigation is the primary investigating agency.
I know there are probably several or dozens, but what other agencies have you been working with?
FBI, ATF as well, several local state agencies, UVU Police, Orem Police, Utah County Sheriff, Washington County Sheriff, St. George PD, most of all the agencies within Utah County and even others outside of the county. So we've worked with a lot of agencies with this case. It was a pretty large scale investigation.
You mentioned ATF. What does that stand for?
Alcohol, tobacco, firearms.
All right. I know a lot about so as a case agent, have you been in court during this preliminary hearing?
Yes.
You've heard prior testimony?
Yes.
We've talked a lot about the events of September 10th of 2025. I want to direct your attention to September 11th, 2025. Do you remember that day?
I do.
What happened on that day in relation to your investigation?
I spent the day at the command post with various assignments. That evening, it was about 8:30 p.m., I believe, of the 11th. I received a phone call from Sergeant Elsholz requesting that I travel to St. George.
Who is Sergeant Elsholz? What agency is Sergeant Elsholz with?
With SBI.
And he requested that you travel to St. George?
Correct.
What was the reason stated for that?
We received information that an individual was turning himself in, or was going to turn himself in to police in regard to his involvement with the incident, the shooting on UVU campus.
And I'm sorry, what time did you get that information, that call?
About 8:30 p.m.
Did you travel down to St. George?
I did.
On what day?
Of September 11th.
Did anyone else go with you?
Yes, so we traveled to the Salt Lake City Airport to a hangar there, and we were flown down on a fixed-wing aircraft. It was Sergeant Elsholz, was Agent Folger with FBI, Agent Anderson with FBI, Ryan McBride, and myself, and the 2 pilots
And who is Ryan McBride?
with the Utah County Attorney's Office.
What time did you arrive in St. George?
We landed probably about 11:30 p.m. at the St. George Airport.
And again, this would be the evening of September 11th, 2025?
That's correct.
Where did you go once you landed in St. George?
There we were transported via ground to the Washington County Sheriff's Department.
Did you coordinate at that time with any other law enforcement agencies down in southern Utah?
Oh, we did.
You did?
We did, yeah.
What other agencies?
Well, with FBI, as we were traveling, and then along with mainly the Washington County Sheriff's Department, we also have agents with an SBI assigned to the southern Utah area. So working with them as well, just making plans and coordinating resources and manpower and personnel.
And you stated you went to the Washington County Sheriff's Office.
Yes.
What time did you arrive there?
Probably somewhere close to midnight, maybe just a little bit before midnight of the 11th.
What happened next?
So we met several other investigators, agents, and detectives there, along with some other prosecutors. There were some federal prosecutors as well that were present. And from there, we began kind of making plans, determining how to handle the situation there.
You mentioned the reason you went down there was you had been told that an individual wanted to turn themselves in.
That's correct.
Did you observe that individual?
I did.
And where was that person at the time?
So when we arrived, we went into the room that we were in. It was one of their office, the cubicles there. On the wall, there was a television monitor where I viewed an individual on that screen that was sitting in one of the soft interview rooms. That room was equipped with audio video recording device, and so I observed him on that screen at that time.
Were you aware, or did you become aware what time that individual arrived at Washington County Sheriff's Office?
I was told he arrived there about 9 p.m. that evening.
And was he with anybody else?
He had been, he'd come there with his parents and a family friend.
Did you speak with this individual that we've been talking about?
Yes, I did.
Did you get his name?
Yes, we obtained his name and date of birth.
What was his name?
Tyler Robinson.
Did he tell you that himself?
He did.
You mentioned other individuals came there with him. And then you also said that you had kind of coordinated with the team of law enforcement officers that were there. Were those other individuals spoken with by law enforcement?
They were.
Let's go through them. How did that happen? Who was spoken to first of the other individuals?
So Tyler's mother was interviewed by SBI agent Holgreen and FBI agent Cox. And then kind of simultaneously, his father was being interviewed by SBI agent Terry and FBI agent Smith. And also at that time, the family friend Mike Mitchell was interviewed by other agents as well.
And you said that these interviews were being conducted simultaneously?
Yes.
Were you part of the interview with either of Tyler's parents?
Yes. Yes, myself and Agent Folger. Did I misspeak earlier? Myself and Agent Folger interviewed the mother.
All right, let's make sure the record's clear on that. So Agent Folger, what agency is he with?
With FBI.
And yourself interviewed Tyler's mother?
Yes, that's correct.
I just want to make sure the record's clear. Who interviewed Tyler's father?
Yeah, I think I might have misspoke. It was Agent Holgreen, Agent Cox that met with his father.
And then who spoke with family friend Mike Mitchell?
Agent Terry, Agent Smith.
Down in St. George, Washington County Sheriff's Office, was Mr. Robinson detained at that time?
Yes, he was.
Was he formally arrested at that time?
Yeah, following, after all the interviews were completed, when we talked to everybody, then he was formally arrested at that time.
And I'm going to come back to that in a second. Excuse me, where did the arrest take place?
At the Washington County Sheriff's Office.
And what date did that happen on?
Would have been September 12th. It was about 4 a.m., I believe, of September 12th.
All right, I want to show just on your screen, not for public yet, what's been marked for identification as State's Exhibit 15. Let me know when you're able to see that.
Okay, it's there.
Before I ask you about that, did you have an opportunity to, you stated that you observed Mr. Robinson at Washington County Sheriff's Office, is that right?
Yes, that's correct.
Your Honor, could I have a moment with Ms. Hunt? May I have a moment with Ms. Hunt?
You may.
You're just going to do the redacted version.
Thank you.
And that may happen a couple more times as we go through exhibits
I
because of agreements and disagreements that we have.
Thank you for the heads up.
At Washington County Sheriff's Office, where you initially observed Mr. Robinson, you stated that he was in a room. Is that room equipped with video recording?
Yes, it is.
Is that standard practice for a facility like that to have video recording in such a room?
Yes, very, very common.
Have you reviewed that video?
I have.
And in your review of that video, does it fairly and accurately depict Mr. Robinson at that time?
It does.
You see on your screen what's been marked as State's Exhibit 15. Do you recognize that?
I do.
What is that?
That's the interview in which Mr. Robinson was seated and waiting.
State moves to admit Exhibit 15.
Ms. Hunt, and the other two steps, what's your request?
We would ask to admit it into evidence. We have, defense counsel and I have agreed upon, I guess, redaction of the video, and I would ask to publish it both to the courtroom and to the media.
Mr. Novak?
It's silent, correct? Ms. Hunt?
Yes.
Yes, Your Honor, Ms. Hunt is correct. The state had originally proposed a longer image with audio, and we've agreed to a shorter image without audio. And so
That's correct. Yeah.
So we're fine with all three steps as to this exhibit.
All right. Does the state wish to review this to make sure that what's queued up comports with what you believe? If not, we can move forward. I just want to allow all parties the opportunity to double check.
Let me just confer with my paralegal.
Oh, that's probably right. The difference.
It's has no audio, so we would like to admit and publish it at this time.
All right. State's Exhibit 15 is admitted pursuant to discussion and may be published in the courtroom and may be recorded or transmitted electronically. Just
And Your Honor, of course, this is subject to all of the objections which have been previously reserved in writing and reiterated over the last couple of days. I assume that we don't need to start over with that today.
thank you. I appreciate that. I note the standing objection by defense as previously made, and that objection is overruled, and this exhibit is admitted.
And in this case, it wouldn't be the 1102 issues, it would be the electronic media coverage of the proceeding.
Thank you for that clarification, Mr. Novak. I appreciate that. All right, with that, to the media, can you view that screen okay? All right. All right, State's Exhibit 15 may be played.
And Agent Davis, who are we seeing here?
That's Tyler Robinson.
And although we are watching it on video, what is he wearing at this time?
He's working a dark colored baseball cap with has like I believe it's like maybe the Hurley symbol on it, like a white symbol on front. It's a burgundy short sleeve shirt with no graphics. It's blue jeans and gray and white tennis shoes. I believe they're Converse style tennis shoes.
Thank you. Was Mr. Robinson, you stated that he was arrested in the early hours of September 12th, is that right?
Yes, that's correct.
Did he remain in Washington County Sheriff's Office, or was he taken somewhere else?
No, he was transported from there to the Utah County Jail.
Prior to being transported to the Utah County Jail, was any, I guess, personal property taken from him, clothing, anything like that?
The only thing that was, so prior to like our arriving to the St. George, to the Washington County Sheriff's Office, his cell phone was seized and taken from his person. But that was the only thing that was taken from at that time.
After he was transported to Utah County Jail, were any personal items taken from him?
Yes, they were.
And what were those?
After a search warrant was granted, his clothing was recovered, along with buccal swabs to collect his DNA and major case prints, which is fingerprints, palm prints, pretty much the entire hand. Those are all collected from him.
And sorry, you may have already stated when did he arrive in Utah County?
We arrived at the Utah County Jail about 7 a.m. on the 12th, September 12th, and he was formally booked in at about 8 a.m. of that morning, and then I was the booking officer.
What does it mean to be the booking officer?
I filled out the necessary paperwork essentially with the jail, which gives the individuals personal identification of the charges, the probable cause statement, and then it's signed and submitted to the system.
All right, I want to talk a bit about search warrants, some of the search warrants that were executed in this case. As part of the investigation, were search warrants obtained specifically for areas in southern Utah?
Yes, they were.
And obviously do not give me exact addresses, but generally for what locations?
It was the residence of Tyler Robinson and the residence of his parents.
Were those warrants executed?
They were.
By whom?
The residence of Tyler Robinson was a team led by Sergeant Famuina with SBI, along with the Utah State Crime Lab. And the residence of his parents was a team led by the FBI, their evidence response team.
Are you aware of what date or dates, if applicable, those warrants were executed?
Yeah, September 12th. I believe Tyler's residence, they started the search warrant about 8 o'clock in the morning, and then his parents' residence, they started about 4 p.m. Of September 12th.
So to be clear, you've stated who was involved in executing those warrants. Were you physically present for the execution of either of those warrants?
No, I was not.
Are you aware of whether Mr. Robinson lived with anyone else at that residence at the time?
Yes.
Do you know who that was?
Lance Twiggs.
And we won't get too into it right now. We'll cover this with Sergeant Faumina, but did you receive information from officers involved in those execution of those warrants about what, if anything, had been found?
Yes, I did.
All right, turning to another area. As part of this investigation, you have previously mentioned that a family friend came in initially with the Robinsons. Who was that family friend?
His name was Mike Mitchell.
And who is he in relation to the Robinsons?
So he's a family friend, a good family friend.
And what was his involvement here?
So he helped facilitate working with Tyler and his parents with the sheriff's department for Tyler to turn himself in.
And I believe you mentioned previously that law enforcement conducted an interview with Mr. Mitchell.
They did.
Remind us when that interview occurred.
So that was the early morning hours of September 12th at the Washington County Sheriff's Department.
And I know you've already stated, but remind me who was present for that interview.
That one was Agent Terry and Agent Smith.
What agencies are they with?
Terry's with SBI and Smith is with FBI.
Are you aware if a second interaction or statement was collected from Mr. Mitchell?
Yes, it was.
When did that happen?
It was March 31st of this year.
Who was present at that time?
It was Ryan McBride, Chad Grunander, Kimberly Derfler, and Agent Chris Terry with SBI.
You mentioned Ryan McBride, Chad Grunander, and Kimberly Derfler. What office do they work for?
The Utah County Attorney's Office.
And you mentioned Agent Chris Terry.
Yes.
So you were not present for this collection of this statement.
No, I was not.
Have you communicated with Agent Chris Terry about how this happened?
Yes, I have.
How did this happen?
So all those individuals met with Mike Mitchell at it was the St. George courthouse there. They met and discussed briefly. Just going to kind of talk generally about the situation. From there, Mr. Mitchell was given a handwritten 1102 paper statement, and he left the room, went into a separate office by himself, was there for about an hour where he hand wrote a statement, filled the statement out. When that was complete, he came back into the room where the others were waiting and provided that 1102 statement to them.
We've heard quite a bit about 1102 statements. Sounds like there's an official form that is used. What's present on that form, if you know?
There's an admonition or warning given on those forms that states that the information you're giving is true and accurate to the best of your knowledge, that any false statement that is given or may be given would be punishable by a Class A misdemeanor.
Aside from that being written on the form, are you aware if this admonition was discussed with Mr. Mitchell?
It was.
Do you know by whom?
Yeah, Ryan McBride provided that admonition to him.
And you stated that Mr. Mitchell then went into a separate room for about an hour and wrote his statement down?
Correct.
Did anyone, including prosecutors or law enforcement, direct him what to say?
Foundation, objection. Personal knowledge.
Would you like to respond, Ms. Hunt?
I can lay a little more foundation.
All right, so I'll sustain the objection for now, and Ms. Hunt is moving forward with laying more foundation.
You discussed with Agent Chris Terry about how this statement was obtained?
Yes.
Did he mention anything to you about anyone directing Mr. Mitchell about what to say or what to include in the form?
No, I spoke to him personally and reviewed his report also.
I'm going to show you what's been marked for identification as State's Exhibit 14.1. Let me know when you see that on your screen.
Okay, I see it.
What is that?
This is the written 1102 statement that was provided by Mr. Mike Mitchell.
Your Honor, may I have a minute with Ms. Hunt for the same purpose?
All right.
And how do you know that?
I've reviewed it. I reviewed it in its original. As soon as it came to us, I've seen it prior. So.
And Kimberly, if I can have you slowly scroll down. Sorry, Judge, if I can just have a moment.
You may.
I apologize, Your Honor. I misspoke. It's not 14.1, it's just Exhibit 14.
Okay.
So if we can place that again on the screen for the witness only. Yes. And sorry, we had been scrolling through that. Do you recognize that?
I do.
Does it depict, is it fair and accurate from what you remember?
Yeah, with the exception of the redactions, yes, it's fair and accurate.
And Judge, I'll make a record. Defense counsel and I have stipulated on the redactions that are present. I would move for its admission, states Exhibit 14, into evidence, but we do not wish to publish it either to the courtroom gallery or the cameras.
All right, could I have a copy of it? What I have is the unredacted version, so I want to review it before I make that decision.
If I may approach.
You may. Thank you. All right, I've had a chance to review State's Exhibit 14 and noting the standing objections by defense concerning 1102s. The court accepts into evidence State's Exhibit 14 and pursuant to the parties is not published.
Thank you, Judge. All right, I want to move on to another topic. You've stated that you've been present for the duration as the case agent of the preliminary hearing. Is that right?
Yes.
We heard testimony yesterday about turning to the scene at UVU on September 10th, that a bullet was found on a roof. Do you remember that testimony?
I do.
Do you have knowledge about that bullet, what that is about?
Yes, I do.
What roof was that bullet found on?
I believe it was found on the computer science building on the roof, on the far east side of the roof of the building itself.
How do you know that it was found there?
I reviewed the agent's report that that found that, documented it, and collected it.
What agent was that?
It was Agent Ben Schneider with SBI.
Are you aware of where the computer science building is on campus?
Yes, yes.
Can you explain generally where that is located?
Yeah, from where the LOSI building is, it's a building directly kind of south and east of there, from the LOSI.
Southeast from the LOSI building. Where is it in connection to the auditorium section that we've been talking about where Mr. Kirk was stationed?
It's east of there. East and a little bit south, and mostly east.
Would there have been, from that roof of the computer science building, to your knowledge, would there have been a line of sight to Mr. Kirk's tent?
No, not according to the agent. Agent Ben Schneider, there was not a line of sight from there to where the tent was, where Mr. Kirk was.
Did you learn from Agent Snyder what caliber that bullet was?
Yes, I did.
And what was that?
It was a .223 caliber.
What is a live round?
It's a round that had not been fired, so it still had the projectile, and it was a fully functional bullet with ammunition with the bullet.
Did you learn if this .223 bullet found on top of the computer science building was a live round?
Yes.
And how do you know that?
It was still intact. Still had the primer had not been was not dented, not been fired. It still had the bullet projectile in the end, and still sealed.
Did you observe this bullet personally, or is this information you're getting from Agent Snyder?
From Agent Ben Schneider.
All right, turning to a different topic. And Judge, I'm aware that there are going to be some objections about this that we'll have to address, but I just want to lay a little bit of foundation first before we get there. You've mentioned him already. Are you familiar with an individual named Lance Twiggs?
Yes, I am.
And who is he in regards to this investigation?
He's the roommate of Tyler Robinson.
Was he interviewed as part of this investigation?
He was.
How many times?
2 times.
When was the first time?
The first time was the early morning hours of September 12th, and that occurred at St. George Police Department.
So we've heard of several people coming in and being spoken with at Washington County Sheriff's Office.
Correct.
Mr. Twiggs was spoken with at St. George PD.
Correct.
Do you know who was present for that interview?
It was FBI agents Larson and Agent Ling.
Are you aware of Mr. Twiggs' buccal swab was taken at that time?
I don't recall it happening there. I believe it happened later. I'd have to, but it did occur. That was obtained from him.
Okay. But you're not sure if it happened on the 12th?
I don't recall if it was there or later at his residence, but.
But ultimately, a buccal swab was obtained from Mr. Twiggs?
Yes, it was.
Do you know if his phone was taken from him?
It was.
When did that happen?
So it was during that interview with FBI at St. George Police Department. They conducted an interview of him, and then he provided his phone. He did it voluntarily also, provided it to those agents.
And that would have been on September 12th, 2025?
Correct.
You mentioned a second interview of Mr. Twiggs?
There was a second interview, yes.
When did that take place?
April 20th of this year.
Where was that?
Happened at the Utah County Attorney's Office.
Who was present at that second interview?
It was Mr. Twiggs with his attorney, Joel Cottrell. It was Lauren Hunt, Sam Peed with the U.S. Attorney's Office, Ryan McBride, Sergeant L. Scholes, well now it's Lieutenant L. Scholes, and myself.
We've talked about 2 interviews of Mr. Twiggs, one on the morning of September 12th, 2025, second on April 20th, 2026. Are you aware if both of those interviews were recorded?
They were.
Have you reviewed those recordings?
I have.
Before Mr. Twiggs' interview on April 20th, 2026, well, first let me ask you this. Are you aware of what use immunity means?
Yes.
What does it mean?
it's a letter that the use of immunity is essentially giving the individual, during the limited time of their statement, they're given that immunity from statements that are made in regard to an incident. But it does not preclude them from prosecution from evidence that would be known or found then or later outside of that interview. It just gives them that limited immunity during the type of the interview.
Okay, so for any statements made during the interview, they're given immunity for that, but they're not generally prohibited from being potentially prosecuted outside of that interview. Is that fair?
That's my understanding, yes.
Was Mr. Twiggs given use immunity?
Yes, he was.
By what offices?
The Utah County Attorney's Office as well as the United States Attorney's Office.
You mentioned that both of Mr. Twiggs' interviews were recorded. Have you reviewed those recordings?
Yes, I have.
Do they fairly and accurately depict those interviews?
Yes, they do.
We've talked about 1102 statements. We've talked about a form, and you talked about that there's an admonition on there that warns that if false statements are given pursuant to 1102, then that person may be subject to a Class A misdemeanor. Is that fair?
Yes, that's correct.
Was a similar admonition given to Mr. Twiggs during his second or before his second interview on April 20th, 2026?
Yes, it was.
By whom?
By Ryan McBride with the Utah County Attorney's Office.
And again, you were present for that interview?
I was.
Did Mr. Twiggs say that he understood that admonition?
He did, yep, yes.
Was he told that the April 20th, 2026 interview was being taken in lieu of him having to come and testify at the preliminary hearing?
Yes, it was. Yes, he was.
All right, Judge, I'm aware that defense counsel has objections to this recorded 1102. I think now is probably a good time to address them. But I do have, I guess, I understand that they are suggesting redactions to the video. I have some procedural objections first, and if Your Honor sustains those, I think it may make the substance of the statements or the objections or the redactions that defense is proposing moot. So I'm wondering if Your Honor will entertain my responses procedurally first before we get into the substance of what defense is objecting to. Does that make sense?
Yes, but and if you want to move it, because right now nothing's before me.
Yes. Well, what I want to move, so defense is proposed about a day and a half ago. They created a transcript. Mr. Novak has proffered this earlier to Your Honor. On April, and I'll give you a little more proffer. On April 28th, 2026, the Utah County Attorney's Office provided this recorded 1102 statement of Mr. Twiggs to defense counsel. They have acknowledged the receipt and mentioned the recorded statement at previous hearings. In fact, they even filed a brief that Your Honor has decided about whether 1102 can be applicable to Mr. Twiggs at this hearing, which Your Honor has ruled upon. Monday at about 4 p.m., defense counsel sent us a transcript that was prepared by the defense team, and it had significant redactions that they were suggesting. It was about a 21-page transcript, and their suggested redactions are approximately 11 pages of it. In total, redactions appear on 16 of the 21 pages. My procedural objections to this are that this is essentially by surprise. We were already a day into the preliminary hearing. Defense counsel had been aware since at least April 28th, 2026, when the recorded 1102 of Mr. Twiggs was provided to them, that is how we intended to proceed. And like I said, they had already briefed the 1102 issue as it relates to Mr. Twiggs. At that time, they did not raise any objections to the substance of it or propose any redactions that they wished. And yeah, frankly, it's by surprise, and it's at this point disrupting the hearing. It's not, I did mention that defense prepared a transcript of this recorded interview, how the state intended to present it and how we have given it in discovery to defense is it's a video, audio and visual. Making redactions to that is not as simple as a transcript where you can just, block out sections of the text. So it's far more complicated than that to edit or redact portions of the video at this time. So we would object procedurally, basically on the timeliness of it. That they had an opportunity to make these objections if they had them at the time when the 1102 issue in regards to Lance Twiggs was briefed and decided by Your Honor. They did not do that or raise the issue at this time. And so we would object just procedurally on those grounds. Additionally, the remedy requested, which I'm assuming is that we make redactions to the video or present it as a transcript rather than a video, is disproportionate. Even assuming if there are isolated statements that the court would not ultimately consider, again, as Mr. McBride pointed out and as Your Honor has stated throughout this hearing, this is a preliminary hearing to the court. It's not to the jury. The court is fully capable of disregarding any statement it determines exceeds the proper scope. As Mr. McBride cited this morning, several cases give Your Honor that authority and presumption that judges are able to basically make the difference between what's admissible evidence and disregard what may not be at a preliminary hearing or even at a bench trial. State v. Adams is one of those cases. If Your Honor wants the citation, again, I'm happy to give it. State v. Featherson is another one. That one is 781 P2D 424. State v. Hannigan is another one, 2014 UT App 165. And State v. Rosecrans, 2024 UT App 128. And those cases all stand for the notion that essentially judges, and this is to quote from Rosecrans, judges are not subject to many of the same concerns about prejudices and improper influences as jurors. And so, again, procedurally, the remedy asking us to now, in the middle of a week-long preliminary hearing of which everyone was aware, edit or alter or redact portions of this video recording 1102, that remedy is disproportionate. If there are any potentially objectionable statements within that, Your Honor has the ability to disregard those. And so we would prefer not to get into the substance and argue each statement line by line, and we would prefer to just move for its admission and have the court use its discretion as a judge to take what's proper versus improper, disregard anything the court might find improper. If we would like to move into substantive objections, then we're happy to, but if the court can rule on those procedural objections first, it may make any substantive objections moot.
All right, so you're moving into Evidence States Exhibit 16?
Yes.
And as it relates to publication, what is your request?
So, Judge, we believe, and I believe this has been discussed before on the record, that the state is in agreement that the media should not have the ability to handle or replicate certain exhibits. Because it's video, Mr. Twiggs is shown certain exhibits. So we would agree that this should not be captured by cameras and projected by the media outside of the courtroom. But we would like at least the audio and maybe even the video within the courtroom itself to be captured, is the state's position.
All right, I want to make sure I understand. So your request is that the video not be projected and captured by the video camera, but the video and audio is played in the courtroom and the audio is able to be transmitted just not the video via the camera. Is that my understanding?
Correct, that's the state's position.
All right. And in regards to this exhibit, is in the, as states Exhibit 16, is there any portion of that recorded statement that occurred before the the 11:02 warning was given to Mr. Twiggs?
Not that we are presenting today.
Okay. All right, turning to the defense. Mr. Novak.
Thank you. Thank you, Ms. Hunt. So I'm going to address first, Your Honor, what Ms. Hunt describes as the procedural issues with our proposed redactions. Many weeks ago, the state lodged their anticipated exhibits with the court. And then the court said, I'm not going to review them. In fact, I'm returning them. I'm sorry. The court said that the court is returning the exhibits to the state. So there is no moment to make objections to an exhibit which the court is not inclined to entertain until the moment, as the court has said many times, until the exhibit is presented. And so what we have done is we have given the state, it's only a 20-page transcript, excuse me, it's only a 20-page transcript. We have given the state a transcript we prepared ahead of time so that the state could make sure that the transcript is accurate. The state has never said that the transcript is inaccurate, so I'm going to assume for purposes of the moment that the state doesn't have any dispute that the transcript is an accurate transcription of Mr. Twiggs' recorded 11:02 interview. There's no surprise here. There's been all of Monday evening, all of Tuesday, this morning. In fact, the state informed me yesterday morning that they don't agree to the redactions. So there's no surprise here. And we're actually doing exactly what the court signaled should be done, which is at the time an exhibit is proffered, objections shall be made. This wouldn't be as much of a problem if Ms. Hunt had just said to Your Honor, following Archuleta, and in light of the electronic coverage of this proceeding, and in light of Mr. Robinson's right to a fair trial, the court will consider those portions of the exhibit which are admissible, and the court will not consider those portions which it determines are not admissible, but it will not be broadcast either audio or video. So that becomes a problem because the categories of objections that we have to this video recording, I'm going to talk about a little bit so that the court understands why Ms. Hunt's suggestion that the entirety of an exhibit, which may not be admissible under the rules of evidence at a preliminary hearing, be played in open court, and that the audio be captured by electronic media and broadcast. Because of our client's right to a fair trial, that's a problem. And I don't want to sound flippant, but this is actually the Ryan McBride 11:02. The vast majority of this video is Mr. McBride testifying and Mr. Twiggs agreeing. If we were in a courtroom, it would be a leading examination virtually from start to finish. I don't want to say that every single statement by Mr. Twiggs is just an affirmation of what Mr. McBride says, but the vast majority of it is. There are also portions of this 11:02 where Mr. McBride is basically testifying as to what other exhibits that this court will see say. So there are 2 other exhibits that this court will be asked to receive into evidence today, which are text messages and a group chat. I'm just going to distinguish between the 2. And so this 1102 statement is basically Mr. McBride saying, and then the chat says this, and then the chat says that, and then the chat says this. He's basically testifying as to what the exhibits say. So in some ways, the 1102, those portions of the 1102 violate the best evidence rule, because I have no doubt that those 2 things that I just talked about are going to be presented to the court by the state.
Chad Grunender, Ryan McBride, Lauren Hunt, David Sturgill, Chris Ballard. For the state, County Attorney Jeff Gray also present.
Good morning.
Good morning, Your Honor. Kathy Nestor, Richard Novak, Michael Burt, and Stacy Visser here for Mr. Robinson, who's seated at council table.
Good morning.
Good morning.
Good morning, Mr. Robinson. And for the record, the court also recognizes the presence of Ms. Erica Kirk. Sorry. Good morning, Ms. Kirk. All right. As you've probably come to expect, I do need to read the following as it relates to today's preliminary hearing. The court is mindful of the safety and well-being of all parties, counsel, witnesses, court staff, and members of the public who may be present. The court is also mindful of its duty to protect and uphold the constitutional rights of both Mr. Robinson and Ms. Kirk. To serve those important interests, the court reminds all persons who will be in attendance that portable electronic devices will not be permitted in the courtroom or on the 4th floor. And this prohibition does not apply to legal counsel and support staff for the defense or the state or the media in this manner, or the equipment permitted under any electronic controlling electronic media coverage order, and includes the counsel for victim representative Ms. Kirk. I do ask the parties, the attorneys, if you will join me in turning off your ringer to ensure that we do not have any interruptions. So I am turning off my ringer, and I invite you to do the same. Every person who is in attendance today and every day will be afforded the dignity and respect due to them, and pursuant to the standing decorum order by the court, all spectators shall be quiet, civil, and orderly. Spectators shall not engage in any distracting, disruptive, provocative, disrespectful, uncivil, or threatening behavior of any kind. Spectators shall not make any audible comments of any kind, shall not shake or nod their heads, shall not otherwise make any gestures during the hearing. Spectators shall not